Case number C-17-141, State of Washington versus Donald J. Trump. Counsel, please make your appearances for the record.
Noah Purcell for the State of Washington, Your Honor.
I'm calling Melody, also for the state.
Welcome.
Good afternoon, Your Honor. Michelle Bennett from the Department of Justice for the defendants, and with me is my colleague also from the Department of Justice, John Tyler.
Thank you. Counsel, welcome. A couple of housekeeping matters to attend to. We are scheduled to conduct this hearing between 2:30 and 4 o'clock. I'm going to have some very brief housekeeping matters at the start, of which I've already used 8 of my 10 allotted minutes. The state will go next. I will tell you that I've given, in effect, 30 minutes to each side. If the state wishes, they can reserve some of their time for rebuttal. They're going first. The federal government's going second. Your prepared remarks, which I'm sure are all very thoughtful and quite helpful, are going to get swallowed by questions, because I have questions that are essential to our resolution of this case, and I need to get those answered. So be prepared for pretty much an interruption from the start. And at around 3:45, having followed the direct presentations and rebuttal, if the state has time left, you're going to hear from the court. It's my intention to orally rule from the bench, but in very conclusory terms, and we will get a written order to follow, so that if you want to have the Ninth Circuit grade my homework, you'll have something that you can get on file there promptly. So that will be the order of the day, and I'm going to hear from the state first, please. Purcell, let me do one other item. Technically, the motion that's before me started off as a docket 3, which was exclusively the state of Washington, and is now docket 19, which is both the states of Washington and Minnesota. We've also had a series of requests to file amicus briefs, and I intend to grant those. So I'm granting docket 26, the ACLU, docket 42, the Service Employees Union, docket 45, amicus filed by the amicus law professors. Sounds like the three amigos. Let's see, docket 46, I may have mentioned, is the Washington State Labor Council, and finally docket 48, which is the amicus Americans United for Separation of Church and State. Those motions are granted. Please note that it's not a motion for intervention. It's simply authorization to file the amicus brief in this particular question. Mr. Purcell.
Thank you, Your Honor. Good afternoon. In the week since President Trump signed the executive order at issue here, 6 federal judges around the country have enjoined or stayed parts of it in response to actions by particular plaintiffs, finding a likelihood of success on the merits of the challenges. The states of Washington and Minnesota are asking you to do the same here today and to enjoin the parts of the order that we challenge. The order is illegal and is causing serious immediate harms to our states, to our state institutions, and to our people. And enjoining the order is overwhelmingly in the public interest. So you're familiar, of course, with the standard for a temporary restraining order. I won't waste your time. I want to first address the likelihood of success on the merits, including the threshold issues that the government has raised, including standing, deference to national security interests, and the facial versus as-applied nature of the challenge.
Well, let me try and derail you here.
Sure.
I'd like to take this in terms of equal protection first.
Okay.
And in particular, how does the equal protection claim apply to all of the order? It was just the 120-day part found in paragraph or section 5A. How does this ban discriminate in any way or violate equal protection when it's an across-the-board ban?
You're talking about as to refugees? our claim about refugees is primarily that it is religiously motivated discrimination, and that the order is in large part motivated by religious animus. So that doesn't require us to show that everyone harmed by the order is of a particular faith. It just requires us to show that part of the motivation for issuing the order was religious discrimination.
Then I'm going to try and put words in your mouth. Are you telling me then that you're not making an equal protection challenge to the refugee ban?
I would say, Your Honor, that we have I would say the focus there is on the religious discrimination aspect.
And we're going to get to there next.
Okay. And of course, would you like me to address that further, or?
No.
Okay.
Let's move on to my second question on
Okay.
equal protection then. Do refugees or visa holders that have never physically entered the country have equal protection rights under the Constitution?
Your Honor, that is not the focus of our claim. I think the answer is probably no, but they do have rights to some constitutional protections, and certainly their friends and family who are here, and we're just talking about refugees now, not aliens, for example, who might have been sponsored by a university or something like that to come here. Our claim is primarily focused on the people who are here or who have been here and left, their families, their employers, and the institutions here.
All right. Has any court ever set aside an immigration law or regulation on equal protection grounds based on rational review? I understand it's not the centerpiece of your, but you've pled it, so you're going to get questions.
You did plead it, and that's just fine, Your Honor. I was planning to start this morning with due process, or this afternoon, but equal protection is just fine. I am not aware of a immigration order being set aside on on equal protection grounds. On the other hand, I'm not aware of any executive order quite like this one, that there's so much evidence before there's even been any discovery that it was motivated by animus, religiously targeted, and just utterly divorced from the stated purposes of the order. And I'm happy to talk about that more in terms of the government is asking for an extraordinary level of deference here, essentially saying that you can't really look at what were the real motives for the order. You can't test its legality, and we just think that's wrong legally and factually. And if you'll spare me for just a minute, indulge me for just a minute, and let me. There's a legal point and a factual point. The legal point is courts often review executive action that has to do with national security for constitutional violations. If you look at cases like Hamdi, Hamdan, Boumediene, the Supreme Court routinely reviews, those were cases involving enemy combatants being held offshore. Here we have a case that largely involves people who have been here, longtime residents who still live here and have lost rights, and we're asking the court to review that claim. They also suggest, Your Honor, at page 21 to 22 of their brief, based on a case called Kleindienst and Kerry versus Dinn, that you can't sort of look behind the stated purposes of the order. They say that if the president gives a facially legitimate and bona fide reason for excluding an alien, the court will not look behind that reason. But there's two fundamental problems with that argument, Your Honor. First of all, those cases dealt with the president's power to exclude aliens who were not here, had not been here, had no right to come back. That is not this case, where we have a case involving people who have been here, have rights to remain here, and rights to return. And in Justice Kennedy and Alito's concurring opinion in that Kerry versus Dinn case, which is the controlling opinion, they held that they would look behind stated motives, even for exclusion of someone who'd never been here, if the plaintiff plausibly alleged with sufficient particularity an affirmative showing of bad faith. And that's at 2141 of the Dinn opinion. And the Ninth Circuit endorsed that standard in the Cardenas opinion, 826 F3rd 1164.
Well, let me stop, because we're keeping this area then.
Okay.
Do you not see some distinction between election campaign statements and then subsequently an election, and then an executive order which is issued with comment at the time the executive order is issued? It seems to me that it's a bit of a reach to say the president's clearly anti-Muslim or anti-Islam based on what he said in New Hampshire in June.
Well, Your Honor, it might go to the weight to give the evidence, I suppose, but I don't think it's sort of off the table, especially given that we're only a week into, well, 2 weeks now, I suppose, but the order was issued a week after the campaign well, after the president took office.
The inauguration.
After the inauguration, I'm sorry. And so it's not as though those are, completely, irrelevant. And moreover, and again, this is before any discovery. We have the president's advisor saying on national television that the president asked him to come up with a Muslim ban. This was after the election. Asked him to come up with a Muslim ban in a way that would make it legal, and that's what they did. And so
Does the executive order mention the word Islamic or Muslim? Let's stay on religious grounds.
No, it does not, Your Honor. It does not. But when we're arguing about religiously motivated targeting, again, the burden is not to prove that it affects every single person of the Islamic faith. The burden is to prove that a desire to discriminate based on religion was one motivating factor in the adoption of the order. And we're at the pleading stage. 4 days after having filed our complaint, no discovery, and there's already an overwhelming amount of evidence to suggest that that's the case, that it was at least in part motivated by religion. And going back briefly just to the national security, and part of the evidence of that, Your Honor, is that the tie to the stated purposes of national security is so tenuous here. I mean, the president apparently had not decided whether the order applied to lawful permanent residents before it was issued. And there's roughly 500,000 lawful permanent residents from these 7 listed countries in the United States. Either those people are an enormous threat to our safety or they're not, and they've changed their mind about that 5 times since Friday. First they said that it did apply to them, and many of those people were excluded from returning to the country. Then they said, then the Department of Homeland Security reiterated that it applied to them. Then the Secretary said that it didn't. And then this is all in our complaint, by the way. You don't have, and then the White House spokesperson said it did not. And then the White House counsel has now issued authoritative guidance, whatever that means, that although there could have been reasonable confusion about what the order meant, it wasn't meant to cover those people. So the point is, if they were an enormous security risk, you would think that they would have made up their mind about that before issuing the order. The second point, Your Honor.
Well, before we leave that one,
yeah.
What do you say to the argument that the 7 countries that were designated, and I'll quote the language, have been designated as, quote, countries the government of which has repeatedly provided support for acts of international terrorism under 8 U.S.C. 1187. Wouldn't that provide a rational basis for the executive order?
Your Honor, that would provide a cover, in our view, for that was maybe one motivating factor. But when you look at the standard of proving a religious discrimination claim, again, you can't just accept at face value the stated purposes. Excuse me. Especially where, again, before there's even been any discovery, there's so much evidence that it was not targeted at the concerns stated. I mean, the order applies to infants, it applies to senior citizens, it applies to students and faculty at our state universities who've never been accused of any wrongdoing. The bottom line, the main point I guess I'm getting at here is that the idea that you just can't review the real reasons for this order or even ask whether there are real reasons beyond what's stated is just not supported by the case law. And so we're asking you to, the main point is the government's saying you cannot look behind the stated reasons, and we're saying that you can. The case law doesn't support that argument that they're making.
Well, would you agree with me that it is only Section 5 that mentions religion?
It's only Section 5 that mentions religion. We would say it's not only Section 5 that's in part motivated by religion.
Well, and the part of that is this resumption of the refugee program after what I think is 90 days for that provision. And then it says minority practitioners of a minority religion in a country. Does your establishment clause cause of action then extend beyond Section 5?
I think our Establishment Clause claim is focused on that section, but I think both 3 and 5 are motivated in part, our allegation is, by preferring one religious view over another. And that's the Larson case that's cited in our brief makes clear that you don't need to have a distinction between named religions on the face of the order for it to be an Establishment Clause violation. In that case, it didn't name any religions. It just set standards for how different religious groups would qualify for a tax exemption. And the court said that combined with the effects on the religious groups was enough. Your Honor, if I want to spend some time on our due process claim.
Oh, you were going to get there.
Okay, excellent.
Trust me.
And also standing. But if I could turn to the due process claim.
Well, before you go there, let's
Sure.
finish establishment.
Okay.
5B isn't implemented for, I think it's 100 days.
Mm-hmm.
Why should I take this up at this time as opposed to, if you're coming back for a motion for preliminary injunction, deal with it when it's somewhat more concrete?
Well, Your Honor, we're asking you to temporarily restrain what we thought was a narrow subset of the categories that we thought were motivated by these unconstitutional, that violated the Constitution. If you want to have further thought about whether, so we're suggesting that the action itself of banning the refugees and the Syrian refugees indefinitely, and the selection of the countries was partially religiously motivated. If you want to wait and to rule on whether 5B itself and that favoritism approach going forward is a constitutional violation, I suppose that would be fine. That does not necessarily require immediate injunction, but that is evidence. I think that provision is evidence of the religious underpinnings of the order.
All right. Once you move on to due process, since I've
Certainly.
used up a fair chunk of your time.
Yeah. So I think the most obvious way in which the order violates the Constitution is its violation of the Due Process Clause. The Due Process Clause protects everyone in this country, including immigrants, and a number of cases make that clear.
Is it your position that refugees and other aliens who are presently outside the country are covered by due process?
Your Honor, the Supreme Court has said that aliens who are not in the country and have never been here, the only process they're entitled to is what Congress provides. And so we're not, again, they're not the focus of our claim. The focus of our claim is on people who have been here and have overnight lost the right to travel, lost the right to visit their families, lost the right to go perform research, lost the right to go speak at conferences around the world, and also people who had lived here for a long time and happened to be overseas at the time of this order, which came with no warning whatsoever, and suddenly lost the right to return to the United States. And so there's a series of cases, and we cited some of these in our brief, Your Honor, but I'd like to, given that there's only been a short time since the government's filing, I direct you to cases like Landon versus Placencia, 459 U.S. 21.
You want to slow down a little bit.
Sorry. Landon, 459 U.S. 21. Rosenberg, 374 U.S. 449, that make very clear that people who have lived here legally for some period of time and then leave temporarily are protected by the Due Process Clause in attempting to return and cannot have their right to return taken away without some sort of process. And that's effectively what happened here to thousands of people in Washington, including hundreds of students at our state universities and faculty. They just overnight, with no process whatsoever, lost these important rights that they had. Now the federal government...
Missing from your list of cases was Katzenbach, which the government cites extensively for the proposition that you've lost that argument.
Right.
How do you respond to that?
Well, they're wrong, Your Honor, for a number of reasons. First of all, so they say we can't cite that case because we're a state. But our claim is not just... Our claim is not the state, as we made clear in our standing brief. Our claim is the state as proprietor and the state as parents patria on behalf of the people of the state. So the state as proprietor, I think, is the most obvious way that that argument of theirs is incorrect, Your Honor. We are asserting the due process rights of, on behalf of the people of the state who are harmed and on behalf of the state institutions that they attend. So, for example, the University of Washington and Washington State University, as well as our community colleges, are arms of the state. It's very clear under state law they're arms of the state. We sue on their behalf. And their students and faculty are being denied due process rights pursuant to this order. And if you look at cases like Pierce versus Society of Sisters, 268 U.S. 510, and the cases cited in footnote 3 of our standing brief, it's very clear that schools and universities have standing to bring challenges based on harms to their students. So that's the first way in which we have standing to bring a due process claim. Second, Katzenbach, of course, is before Massachusetts versus EPA and before the significant change in parents patriae standing that case announced, as detailed in the amicus brief of the law professors and as explained in Massachusetts versus EPA itself. So the SNAP decision, the case out of Puerto Rico, cited in our briefing, makes very clear that states can bring parents' patriae claims asserting discrimination sort of cause of action. And then Massachusetts versus EPA makes very clear that the sort of Katzenbach-Mellon limitations on state standing have been dramatically scaled back, if not eliminated altogether.
Well, what's your view of the Fifth Circuit opinion in the United States versus Texas?
Well, it is a strong basis for standing here as well. That was primarily an Administrative Procedure Act claim, and we do have an Administrative Procedure Act claim here. We didn't have space or time to brief it in our temporary restraining order motion. And I should say there's a number of claims actually in our complaint that we think we're likely to prevail on that we just didn't have time or space to brief in the 48 hours and 24 pages of the temporary restraining order motion. Excuse me. And that's one of them, Your Honor. And that case makes very clear that the harms to the state that we're suffering here are sufficient to generate standing in a proprietary capacity. There, the state was arguing essentially added driver's license costs that were sort of unspecified, the exact amount. And here, we have claimed very clearly lost tax revenue, harms to our state universities in terms of lost, wasted money that was spent sponsoring people to come here to teach and perform research, wasted money that was spent buying tickets for people who will no longer be able to go and speak or research at conferences. A wide range of proprietary harms, Your Honor, that do suffice under U.S. v. Texas to show standing.
Let's go to the INA claim and then leave you some time to actually talk to me. Do states have a right of action under Section 8 U.S.C. 1152A1A?
Your Honor, I'm sorry. I honestly do not have a good answer to that question. I do not. I think we can assert. We should be allowed to assert the rights of our people here as parents patriae who are harmed by the discrimination, the nationality discrimination embodied in this order. But the INA, I think I would say our INA claim primarily supplements our other claims by showing that this action, the President's action here, is not endorsed by Congress. It's not consistent with congressional directives. It is actually contrary to what Congress has said about how these sorts of decisions are supposed to be made, which further undermines the federal government's argument for deference to the President's decision-making in this context.
All right, you've got about 10 minutes, and I won't ask you any more questions.
Your Honor, I'm perfectly happy to have you ask me questions. So I guess first of all, I want to overall emphasize that we have two distinct bases for standing here in terms of our proprietary interests, the harms to the University of Washington, Washington State University, our other state colleges and universities, and then our parents patriae claim. Those are real harms in both senses. The federal government really has offered no meaningful response to our claims of proprietary harm to the universities. I know they've claimed that tax harms are insufficient in some of their pleading, but all of the cases they cite predate Massachusetts versus EPA, and they're inconsistent with, for example, the Fifth Circuit's approach in U.S. v. Texas. If the added cost of issuing driver's licenses is sufficient to generate standing, there's no reason why the lost revenue of losing visitors who would come here and spend money should be insufficient to generate standing. You know, more revenue versus less revenue is two sides of the same coin. And as to the universities, the federal government claims that these harms are quote-unquote illusory because most of the people we allege will be affected actually won't be. But there's just no evidence to support that. I mean, so they say now, again, that the position has changed 5 times. And I don't mean any ill intent towards counsel. I know they don't have any control over this. But the federal government's position about what the executive order means has changed repeatedly since the order was issued. And so now they say it protects long-term lawful permanent residents. It doesn't apply to them. But that was not their initial position. And in any event, we have hundreds of students and faculty at our universities who are here on visas who, again, overnight lost the right to travel for any number of purposes or to return to the country. The only other point I'd make, Your Honor, they make much of the idea that this is a facial challenge. We can't show that it's illegal in all applications. And that's incorrect, Your Honor. The Ninth Circuit has repeatedly held that when in analyzing whether something is a facial or as-applied challenge, you look at whether it's a challenge to the entirety of the action or to parts of it. And that's cases like Hoy versus Oakland, 653 F. 3rd, 835. Here we're challenging only parts of the executive order. It's very clear that this is an as-applied challenge to parts of the order. We don't need to show that it's unconstitutional in every application. I apologize for citing so many cases, Your Honor, in oral argument. I don't normally do that. It's just that, of course, we had no opportunity to file a response in only a short period of time from when they filed. And the last thing I'd say, Your Honor, for now, and then I'd just like to reserve the remainder of my time, is that the Establishment Clause. The Establishment Clause, one of the original purposes of it was to protect the states against the federal government choosing a national religion and imposing it on the states. So the idea that the state would not have standing to challenge a national government, the president anyway, expressing a preference, is just, it makes no sense. And again, I can't cite you to a case where a state sued the federal government over an Establishment Clause violation, but I also can't cite you to an executive order ever before quite like this one, or the circumstances that we are facing today. So I'd like to reserve the remainder of my time and just conclude by saying the question is likelihood of success, irreparable harm, and the balance of equities. We believe we've shown a strong likelihood of success, as the other courts have ruled, and we'd ask you to enjoin this order temporarily. Thank you, Your Honor.
Bennett, are you arguing?
Yes, Your Honor.
Thank you for coming. I thought your brief was extremely well done. It was helpful.
Thank you, Your Honor. May it please the Court. Your Honor, for some of the reasons we mentioned, we think we have very good reasons why the state is not likely to prevail on the merits, but I'd like to start with standing, which I think distinguishes this case from some of the other cases that have been filed around the country.
Well, let's concentrate on the standing. Tell me why you think the Fifth Circuit's wrong in what seem to be fairly marginal circumstances, and they strongly come out without hesitation or doubt to find standing.
Well, Your Honor, we do disagree with the Fifth Circuit's decision. Of course, we also think that that case would be distinguishable. We disagree with the decision because we do think it has to be a particularized impact on the state. In United States v. Texas, the court found that the state itself had injury. It wasn't an injury in its parents' patriotic capacity. And it was basically that the...
Let me stop you. In the state of Washington, I can't speak to Minnesota, but both the University of Washington and Washington State are considered parts of the state government. And they've cited a litany of direct consequences, damages, to them. That's compared to, what, $13.40 in Texas for issuing a driver's license.
Well, Your Honor, in Texas, it was a monetary injury, right? Here, the injuries that the state talks about to its universities in particular are reputational harm, or that students won't come there, that it will undermine their diversity. They don't cite any cases that define a lack of diversity at a university or something like that, even assuming they could prove that as an injury.
I don't think that's their argument. I think they're talking about direct financial harm in their declarations.
I mean, I don't read them that way, Your Honor. I didn't see any sort of calculations of financial harm like there were in Texas. They talked about faculty members that might not be able to teach, although most of those were lawful permanent residents that actually are not affected by the order. They talked about the possibility of some students that might not be able to travel. Most of it was very speculative. I didn't see, the only place that I saw numbers of monetary losses was in their allegations about lost tax revenue. And as we explained in our brief, lots of courts have recognized that sort of generalized grievances like that are not cognizable injuries, and analogizing it to the taxpayer standing context.
If I have a student who's admitted to one of those two universities who's in a country who is now unable to come to the United States, enroll, and pay tuition, is that not a direct financial harm?
Your Honor, we don't think it's a direct financial harm to the state. We think it's, I mean, perhaps given the circumstances, and it would depend on the circumstances, could be a harm to the individual. But
they're benefiting. They're not paying that outrageous tuition. But it's the University of Washington, part of the state of Washington, or Washington State, part of the state of Washington, who are not receiving these dollars from this student who, under the executive order, can't get into the United States.
Well, Your Honor, I mean, first of all, I would point out that I'm not sure that they make those allegations of a specific student, but I would also say that we think that that injury is too far down the chain of causation, that it's an incidental impact. And if Your Honor were to find standing in that circumstance, it's hard to imagine a federal law or a federal action that wouldn't in some way down the line have effect on states, which would essentially allow states to sue to challenge any federal law. If they could point to a way in which some individual was affected by the law because it applied to them, and then that individual, the effect on that individual had some effect on the state. And we think that that's too expansive of a definition of standing.
Well, the odd couple of the Fifth Circuit, in their opinion in United States versus Texas, that seems to me to, basically follow the lines of what you just said is improper.
Well, Your Honor, as I said, we respectfully disagree with the Fifth Circuit's decision, and note, of course, as Your Honor knows, that you're not bound by that decision. Plaintiffs haven't cited anything in the Ninth Circuit that relies on that sort of injury. As we explained in the briefs, some of the cases they cited, I believe the one school case that they cite, involved a bank that had terminated its loan guarantee program with the school. So that was a more direct effect on the school. Whereas here, the government is not regulating in any way the school. The government's interactions are with individuals, and there are perhaps down the line consequences on the state, although we think many of those, and if not all of them, are speculative.
Well, let me move you off of standing, if you would. Given the breadth of authority of the executive in the area of immigration, do you acknowledge any limitation on his or her power?
Your Honor, I don't think Your Honor needs to answer that question to decide on this case.
No, but it seemed like a good question.
Given, I don't think it would be wise to sort of opine on what the extent of the executive's power is. I mean, I think here we have specific circumstances where the President has issued this executive order. It was pursuant to authority that Congress gave him in Section 212F of the INA that specifically allows him to suspend the entry of certain aliens or a class of aliens when he finds that it would be detrimental to the interests of the United States to allow them in. So here we have the President acting pursuant to power that Congress gave him, which means under the Youngstown still seizure cases, he's acting at the apex of his power. And the executive order, as Your Honor mentioned, is tied, the countries that it applies to, is tied to countries that Congress previously, for two of them, explicitly designated as countries of concern, and that Congress designated authority to the President, to federal agencies, to designate other countries, and under the prior administration, the remaining 5 countries were designated as areas of concern. And so we think in the context of, certainly in the context of this case, the President is acting well within the authority that Congress has given him. And Your Honor need not opine on what he may or may not be able to do beyond that. Your Honor, with respect to the plaintiff's argument that the President's authority is somehow limited by Section 1152A1A of the INA, as we explained in our briefing, we don't read that as a limitation on the President's expansive power under 212F. As we noted in our briefs, there have been other presidents that have exercised the power in 212F in ways that distinguish between nationalities, as the President has done here. We also mentioned that these distinctions between nationalities were made explicitly by Congress in 8 U.S.C. 1187, and that's what the President has tied the executive order to here. And so we don't understand 1152A as imposing a limitation on the President's power. If it did, as we pointed out in our brief, you can imagine a situation, it would basically, that provision would prevent the President from suspending the entry of aliens from countries that the United States has to be at war with. And we don't think that that's a fair reading of the statute. So we think that 212F applies in situations where the President has made the determination that the entry of certain aliens would be detrimental to the United States. In situations where when that determination has not been made, then the other provision in 1152 applies to prevent these discrimination, to bar certain types of discrimination in the issuance of immigrant visas.
I'd like to move you along to equal protection,
Sure.
if we can. You strongly urge that strict scrutiny doesn't apply. Can it ever apply in the immigration context in the government's view?
Your Honor, again, I I hesitate to opine on whether it can ever apply as opposed to whether it applies under the circumstances of this case. The courts have made clear that distinctions based on nationality, which is what this executive order does, in the immigration context are completely valid and legitimate and do not violate the Constitution. And so in the context of this case, there's no equal protection violation. With respect to the argument of religious discrimination, again, it's a little bit confusing whether exactly what the state's religious discrimination claim is. We understand it to be limited to Section 5 of the executive order, which is about refugees. And in that context, for reasons Your Honor had mentioned, we think the claim is unripe. But it also, that provision doesn't discriminate against religion.
Well, no, but it may not discriminate, but it favors one over another.
It doesn't, Your Honor. It sets up a system where, and again, it doesn't even set up a system. It says in 120 days from now, once the suspension of the refugee program is back on track, that the executive branch, the Secretaries of Homeland Security and Secretaries of State, are to make changes to the extent permitted by law to prioritize refugee claims based on religious-based persecution where the religion is a minority religion in that individual's country of nationality. Now, Your Honor, that program doesn't just apply, or that provision doesn't just apply to the 7 countries that are designated in Section 3 of the order. It applies to all countries. So you can imagine that while it might be true that the 7 countries are majority Muslim, there are other countries where Islam would not be the majority religion. And in those contexts, the minority religion might be Islam. So,
well, but under the establishment cases, I think you're arguing against your own position, aren't you? What you're saying is in any particular country, we're going to reward someone for belonging to a particular faith or practicing a particular faith.
Well, Your Honor, I don't think we're saying that. I mean, the government has long prioritized or permitted asylum claims or other types of claims in the immigration context based on religious persecution. So the government's not doing anything different than what it's already done. It's not about the particular religion. It's essentially accommodating religion, which the government has always done. But as Your Honor, as we said before, this is something that the President has directed executive agencies to look into this matter going forward. And so certainly until 120 days passes, but we think even beyond that, because until it's actually implemented, we don't know what it's going to look like, that there's no establishment cause problem.
All right, I think I understand your argument. Let's talk about Section 3. So I'm going to do the same thing, trying to leave you some time to just talk as opposed to be interrupted. The rationale for Section 3 is invoking 9/11. And my question to you is, have there been terrorist attacks in the United States by refugees or other immigrants from the 7 countries listed since 9/11?
Your Honor, I don't know the specific details of attacks or planned attacks. I think I will point out first of all that the rationale for the order was not only 9/11. It was to protect the United States from the potential for terrorism. I will also note that the 7 countries that are listed in the executive order are the same 7 countries that were already subject to other restrictions in obtaining visas that Congress put in place, both by naming countries, Syria and Iraq, and that the prior administration put in place by designating them as places where terrorism is likely to occur, or the specific factors, or whether the president's presence in a particular country increases the likelihood that an alien is a credible threat to U.S. security or an area that is a safe haven for terrorists.
Well,
so
let me walk you back then. You're from the Department of Justice, if I understand correctly.
Yes.
So you're aware of law enforcement. How many arrests have there been of foreign nationals for those 7 countries since 9/11?
Your Honor, I don't have that information. I'm from the Civil Division, if that helps get me off the hook any.
Well, let me tell you, the answer to that is none, as best I can tell. So, I mean, you know, you're here arguing on behalf of someone that says we have to protect the United States from these individuals coming from these countries, and there's no support for that.
Your Honor, I think the point is that because this is a question of foreign affairs, because this is an area where Congress has delegated authority to the President to make these determinations, it's the President that gets to make the determinations, and the Court doesn't have authority to look behind those determinations. They're essentially like determinations that are committed to agency discretion.
Well,
and we do think that, despite plaintiffs' claim that Kleindienst v. Mansell is directly on point, and that if the four corners of the executive order offer a facially legitimate and bona fide reason for it, which they do here, that the Court can't look behind that.
Well, Counsel, I understand that from your papers, and you very forcefully presented that argument. But I'm also asked to look and determine if the executive order is rationally based. And rationally based to me implies that to some extent I have to find it grounded in facts as opposed to fiction.
Well, Your Honor, we actually don't think you are supposed to look at whether it's rationally based. We think that the standard is, again, facially legitimate. And that there are some cases that say the Court would have to find it wholly irrational. And again, Your Honor, I would point to the fact that Congress itself has specifically designated two of these countries as areas of concern with respect to terrorism. And the Obama administration, the executive branch, designated the remaining five. And so it's not that this executive order is in that regard saying anything new about these being countries of concern as it regards to terrorism.
Well, let's go back to something you were starting to get around to when I interrupted you. You were going to argue Katzenbach. Isn't that just classic dicta?
Your Honor, I think to the extent you're talking about that states don't have due process.
I'm talking about the language you quote in your brief.
Well, I mean, we also, I think, cited that case for the idea that states don't have parens patriae standing. But for the idea that states don't have due process rights, we cite other cases in our brief. I think that's a well-established. The Fifth Amendment applies to persons, and cases establish that the state is not a person in that regard, and so the state doesn't have due process rights to assert.
Well, then how do I reconcile that with Massachusetts versus EPA?
Your Honor, in Massachusetts EPA, which was a standing case, right? The facts were very specific. There you had two factors that the Court found relevant. One, you had an actual injury to the territorial sovereignty of Massachusetts. The Court talked about how global warming actually affected the territory of Massachusetts, its coastline area that was owned by the state. And the second factor was that Congress had explicitly given states and other parties a procedural right when someone petitioned the EPA to look into global warming and the EPA denied that petition, then Congress created a procedural mechanism for that person to challenge that decision. So the Court said in an area where the state has an injury in fact, it's an injury to its territorial sovereignty, and this explicit procedural right that they're standing. And neither one of those circumstances are present here. Washington, of course, doesn't allege any injury to its territorial sovereignty. It doesn't. Its other alleged injuries are sort of incidental.
But explain to me what you mean by the term territorial sovereignty.
Or it's injury to its territory. So it's pollution of its rivers, for example, pollution of its coastline, pollution of its land.
So the federal government could do whatever it wanted to people who live here, and as long as the land's not damaged, there's no harm? Or there's no cause of action?
Well, Your Honor, I mean, I wouldn't make a statement that broad. I think that the statement I would make here is that when the federal government regulates individuals and there are sort of speculative downstream effects that might affect the state in terms of lost revenue and stuff like that, cases have said no, that's not sufficient, that it's not sufficiently direct, as it was in Massachusetts.
All right. Before I run out of all your time also, what limits does 1152A1A place on the executive?
Your Honor, we think so. In terms of when, as I was trying to explain before, in terms of when the President has made a determination under Section 212F of the INA that entry of certain aliens should be suspended because it would be detrimental to the United States otherwise, we think that trumps the 1152A.
Well,
And so-
let's concentrate on that. You argue this in your brief, that the executive can classify aliens by origin of birth or nationality. And then there is a statute that says the classic anti-discrimination language. How do I reconcile those two concepts?
Your Honor, so we think that the 1152A only applies when the President has not made that designation. And I will, to sort of play this out a little more,
You stop there. Tell me what the authority is for that argument. You make it in your briefing, and you don't give me any authority for it there. You just sort of make the statement that, yes, that's our position. Help me understand where it comes from.
That I think the first principle would be that the court is supposed to attempt to reconcile competing provisions of a statute. I think there's also, Your Honor, a constitutional avoidance point. Here the President is acting in an area of his Article II powers in foreign affairs, and if the court were to find some sort of conflict between the two, the court might run up against the constitutional question of whether the President had authority to make distinctions based on nationality.
Or the executive's running up against the law that Congress has passed.
Well, Your Honor, to the extent that you're concerned about that, I would just note that Congress itself, in the INA, makes those very same distinctions based on nationality in the provision that the President is relying on here in 8 U.S.C. 1187, where it says that different rules in terms of applying for visas apply to, and it names two countries, Iraq and Syria, and then allows the President to designate others. We think that a reading that says that 1152 applies no matter what would trump that provision, or would suggest that provision is invalid.
Yeah, I don't get a lot of chance to do a statutory interpretation, but let's concentrate on that for a moment. As I understand it, 1152A was promulgated after 1182F. Do you agree with that?
Yes, Your Honor.
And didn't Congress then had to, by statutory construction, Congress had to be aware of 1182F?
Yes, Your Honor, that's right.
And in that particular provision, it makes a number of exceptions, but it does not accept to 52.
Because we don't think Congress thought it applied. Again, this is the 1152A is in a narrower section of the statute that talks about creating a uniform quota system for immigrant visas, for which people are going to be allowed to come in this country. And we just think that that's a narrower section of the statute, and that the President's broader authority, again, Your Honor, I hesitate to repeat this, but I think it's a good example. I mean, Your Honor, if this provision of 1158 trumped 212F, then the President would essentially be prohibited from restricting the entry of aliens to a country at which the United States was at war. And we just don't think that Congress could have meant that.
You've shaken those bones about as much as you can get out of them. Why shouldn't the court assume that Congress did not want to accept 1182F from the operation of 1151? I mean, Justice Scalia has not been with us for a year, but it seems to me what you're running to now is, all I got to do is look at the legislative history, and that must have been what they meant.
Well, I don't think Your Honor needs to look at the legislative history. I think you can look at the text and the structure of the statute, that this broader power authorizing the President to suspend the entry of any aliens or any class of aliens supersedes this other provision that otherwise would apply in the absence of that. I would also note, Your Honor, that we also make additional arguments in our brief that about the procedural exemption to 1152A and its narrowness as well. But we think 212F trumps that provision.
All right, you've got about 6 minutes left, so I won't interrupt you either for a bit here.
Okay, Your Honor, thank you. I would just make a few more points. I think I covered largely what I wanted to cover, but with respect to the remaining two preliminary injunction factors, I would just say that the state, we don't think they've established standing and injury, but certainly even if Your Honor disagrees, they haven't shown irreparable harm. As this process has sort of shown, the executive order sets up a case-by-case, or sets up a system where there can be case-by-case waivers of specific exemptions. And so the idea that a state can come in and sort of sue on behalf of all of its citizens without really sort of playing out specific circumstances where it's been applied unlawfully, we think that's not the proper avenue for a TRO. Again, that certainly perhaps some of these individuals could bring their own case, and we'd have to look at the facts of those cases. But as for this facial challenge, for Your Honor to enjoin this restraining order, or frankly even parts of it, even provisions of it, we think that's a facial challenge, and Your Honor can't do that in light of the fact that it is lawful in some of its applications. And then we would just point to the balance of the equities, Your Honor, and note again that in this regard, the President was acting pursuant to congressional authority at the height of his power in the area of national security, foreign affairs, and immigration. So we'd ask that Your Honor deny the TRO.
All right, thank you.
Thank you.
Mr. Purcell? You have about 6 minutes.
Thank you, Your Honor. Just a few points. First, the federal government has argued that the harms to UW and WSU and their students and faculty are abstract. That just couldn't be further from the case. They have students and faculty who are literally stranded overseas, as it's stated in the declarations. They have sponsored visas for people that are wasted because they're not going to be able to come. They went to great time and expense to do that. This harm is much more direct and immediate than what was happening in either Massachusetts versus EPA or Texas versus United States. In Texas versus United States, the immigration program that was challenged hadn't even taken effect yet. No one had even qualified for it yet. The harm was a ways down the road, and the court there still granted a preliminary injunction. Here, there's literally people stuck overseas who can't get back to their universities.
But the causes of action belong to them. The state can't be exercising on their behalf.
Well, but the universities and their students are harmed by those harms, Your Honor. It's the university that spent the money to bring the people here who can no longer come. It's the university that went to the time and trouble of sponsoring those scholars to come, and they're harmed immediately. So perhaps, you know, yes, certainly the people who are stranded overseas may have their own claim, but that doesn't mean that the state has no claim. And Massachusetts versus EPA makes that clear, Your Honor. The federal government also talked about a Ninth Circuit case saying anything remotely like Texas versus United States. We cited the City of Sausalito case on page 2 of our standing brief, where the court found standing based on aesthetic harms to a local government that were not quantified in any sort of monetary way. You also asked me, Your Honor, if a court had ever blocked part of an immigration order based on the Equal Protection Clause and Due Process Clause. And my co-counsel very helpfully pointed out that, in fact, 2 courts have blocked parts of this order based on the Equal Protection Clause and Due Process Clause, and I can give you those orders. It's the Darwish case out of the United States Eastern District of New York. That order was entered on January 28th. Sorry, that order was entered on January 28th. And the I'm going to butcher this name, Tutkabani case out of the District of Massachusetts issued on January 29th. And both of those cases found that the petitioners have a strong likelihood of success in establishing the violations of the Due Process and Equal Protection Clause of the United States Constitution. I don't have all of the orders with me, but at least those 2 have found on this order. The next thing I'd say, Your Honor, is that the religious-based claims, the federal government is trying to limit those only to the refugee portions of the order. Our position is broader than that, Your Honor. We're saying that Parts 3 and Part 5 were motivated in part by a desire to target particular unpopular religious group, Muslims, and that undermines the basis for both of those sections. Your Honor helpfully pointed out that the Katzenbach language is dicta. I'm sorry, I didn't say that, but you're absolutely right. And frankly, the federal government's position about the standard of review here is frightening. I mean, they're basically saying that you can't review anything about what the president does or says as long as he says it's for national security reasons, and that just can't be the law. And the last thing I'd say, Your Honor, is that we are asking here for nationwide relief. We do have now 2 states that are part of this case that are obviously some distance apart. We also have people trying to come to Washington from all over the world through various places, and we believe that nationwide relief is appropriate here for the same reasons that it was in United States versus Texas. So, Your Honor, in sum, the state is grievously harmed here, both in its proprietary capacity and its parents' patriarch capacity. The declarations that are attached to our briefing, the descriptions of people who have been harmed in the amicus briefs are heartbreaking. And it's not just harm to people who are trying to come here who have never been here. Again, that is not the focus of our claim. The focus of our claim is the harm to people who have been here, in many cases for many years, following the law, and traveled overseas without warning that this was going to happen, or can no longer travel and have lost fundamental rights without any process at all, in an order that was motivated largely by religious animus. So we're asking you to enter the temporary restraining order that we're seeking here. Thank you, Your Honor.
Thank you, counsel. I think argument was helpful. The following oral opinion will constitute the informal opinion of the court. It is a formal opinion for purposes of ruling on this motion. But as I indicated to you, I intend to do a formal written order, and hopefully we will have that on file over the weekend, so that by the time the Ninth Circuit opens on Monday, you'll be in a position to be able to seek review of it. Before the court is plaintiff State of Washington and State of Minnesota's emergency motion for a temporary restraining order. For the audience out there, the lawyers refer to those as TROs, and that's not initials that we like to see. The court has reviewed the motion, the complaint, the amended complaint, the submissions of the parties, the submissions of the amici, the relevant portions of the record, and most importantly, the applicable law. And I, too, very much appreciate the fact that counsel have come for oral argument today on very expedited basis. And a nice job of submitting written materials to the court, which are helpful, and also participating in oral argument. I'm going to digress for a moment and remind people who see this opinion and wonder what's going on. Fundamental to the work of this court is a recognition that it is only one of three branches, three equal branches of our government. The role assigned to the court is not to create policy, and it's not to judge the wisdom of any particular policy promoted by the other two branches. That is the work of the legislative and executive branches, and the citizens who ultimately, by exercising their rights to vote, exercise democratic control over those branches. The work of the judiciary is limited to ensuring that the actions taken by those two branches comport with our laws and, most importantly, our Constitution. There is a very narrow question before the court today that asked to be considered, and that is whether it is appropriate to enter a TRO against certain actions taken by the executive that are enumerated in this specific lawsuit. Although that question is narrow, the court is mindful of the considerable impact that its order may have on the parties before it, the executive branch of our government, and the country's citizens and residents. I will not repeat the procedural background of this case. It will be in the written order. But instead, note that with the motion was filed and that the federal defendants oppose the state's motion. Any question regarding lawsuits in federal court starts with the issue of does the court have jurisdiction over the federal defendants and the subject matter of the lawsuit. In terms of notice to the federal defendants, that was certainly accomplished, and indeed the federal defendants have appeared and argued before the court and defended their position in this action. And since this is a attack based on the Constitution and federal law, I find that I do have subject matter jurisdiction. The standard for issuing a restraining order in this circuit is the same as for issuing a preliminary injunction. A temporary restraining order is, as the government has noted, an extraordinary remedy that may only be rewarded upon a clear showing that the plaintiff is entitled to such relief. A citation to the Winter case, which is well known to the lawyers. The legal standard for preliminary injunctive relief, and hence for a temporary restraining order, is that the plaintiff must be likely to succeed on the merits, that it will suffer irreparable harm in the absence of preliminary relief, that the balance of equities tips in their favor, and finally, that the injunction is in the public interest. The Ninth Circuit has an alternative test which it's used from time to time and is well known to the parties, and it will be in the written order. It is an interesting question in regards to the standing of the states to bring this action. I'm sure the one item that all counsel would agree on is that the standing law is a little murky. I find, however, that the state does have standing in regards to this matter, and therefore they are properly here. And I probed with both counsel my reasons for finding that, which have to do with direct, immediate harm going to the states as institutions, in addition to harm to their citizens, which they are not able to represent as directly. Therefore, turning to the merits, the court finds that for purposes of the entry of the temporary restraining order, that the state has met its burden of demonstrating that it faces immediate and irreparable injury as a result of the signing and implementation of the executive order. I find that the state has satisfied the test that it is likely to succeed on the merits of the claim, which would entitle them to relief. I find that the balance of equities favor the states. And lastly, I find that a temporary restraining order is in the public interest. If I were to apply the Ninth Circuit's alternative test, I would find that the states have established a serious question going to the merits, and that the balance of equities tips sharply in their favor. As such, I find that the court should and will grant the temporary restraining order. The scope of that order is as follows. Federal defendants and all their respective officers, agents, servants, employees, attorneys, and persons acting in concert or participation with them are hereby enjoined and restrained from A, enforcing Section 3C of the executive order, B, enjoined and restrained from enforcing Section 5A of the executive order, enjoined and restrained from enforcing Section 5B of the executive order, or proceeding with any action that prioritizes the refugee claims of certain religious minorities, enjoined and restrained from enforcing Section 5C of the executive order, and lastly, enjoined and restrained from enforcing Section 5E of the executive order to the extent Section 5E purports to prioritize refugee claims of certain religious minorities. This TRO is granted on a nationwide basis and prohibits enforcement of Sections 3C, 5A, 5B, 5C, and 5E of the Executive Order at all United States borders and ports of entry pending further orders from this court. I considered the question of the government's request that the order should be limited to Minnesota and Washington, but I find that such partial implementation of the executive order would undermine the constitutional imperative of a uniform rule of naturalization and Congress's instruction that immigration laws of the United States should be vigorously and uniform. That's language from Texas versus the United States, 809 Fed 3rd 134 155, 5th Circuit 2015. I find that no security bond is required under the Federal Rules of Civil Procedure 56C, and I direct that the parties confer and get back to the court promptly. Today wouldn't be too late, but by next week, regarding a date for the preliminary injunction hearing, the time for the motion for the preliminary injunction, the time for the federal defendants to file their opposition, and for the states to file their reply. Once we know that, we'll promptly schedule a hearing on the motion for preliminary injunction after we are in receipt of the parties' briefing. The court concludes that the circumstances that brought it here today are such that we must intervene to fulfill the judiciary's constitutional role in our tripart government. Therefore, the court concludes that entry of the above-described TRO is necessary, and the state's motion is hereby granted. Counsel, anything further at this time? Mr. Brazell? Ms. Bennett?
One more thing, Your Honor. As a procedural matter, the government would move, Your Honor, to stay the TRO, the same purposes that we oppose the TRO, pending a decision by the SG of whether to appeal, to file an appeal.
I'm sorry, pending a decision by the...
By the Acting Solicitor General. I'm sorry, Your Honor. We use lots of acronyms.
Yes.
But by the Acting Solicitor General.
I understand the motion, and I'm going to deny it.
Thank you, Your Honor.
I will do everything I can to get you prompt appellate review, which I think is the appropriate case to take.
Thank you, Your Honor.
We will be in recess. Thank you, counsel.